26, my lord, which was Friday. We have put a challenge to that particular order, my lord. If it can be taken up today, my lord.
Challenge to which order?
To the order of the State Chief Information Commission, my lord. It has directed us to give certain documents, my lord. But then our points is that he has not complied with certain sections of the law, my lord, of the Act, Right to Information Act.
You have filed the writ petition?
On Monday, my lord. We had already filed, my lord.
Day before yesterday?
Yes, my lord.
Okay, we'll see. We are sitting as DB at 2.
Yes, my lord.
So if it doesn't come in the first half, then after DB.
All right,
Yes.
my lord. Obliged, my lord.
Lordship, may I mention item number? It's PIL 2/25. It's in DB. Lordship, I have come personally for appear physically before the Honorable Court, but now the Honorable Court is sitting at 2 o'clock. I am seeking only permission to allow me to appear through VC because I have flight at 4 o'clock. So in case if the Lordship can allow me to appear through VC.
Which case?
It's a Mizoram Truck Driver Association.
Dear Milad, they were Minna Mena Milad. Earlier, there's Hori Jaiswal and Hazirimal Mena was there Milad. Now, this Arbin Mena was posted as a deputy CP in Milad. So, Milad, this I informed this and another. If Lordship takes the matter, Milad, then matter may be on 24 month, day after tomorrow. Matter may hard mill because I have some personal difficulty today, Milad. There is another writ petition also. Item 18 is a writ petition which challenges the assessment order, and there is some review also filed. My lord, after that, my lord, the writ petition was revived again. My lord, WPC 112 up to 2024. My lord. So, if Lordship take up the matter,
Mr. Mehdi.
Yes, my lord.
What do you want? Be clear. What do
My
you
lord,
want? You want adjournment?
Yes, my lord, up to 24. Next matter may fix 24, my lord, or 24 or 27.
Why?
Any date, my lord.
Why do you want adjournment?
My lord, today I have some personal difficulties, except from family problem, my lord. I have to go to from medical, my lord, some personal, my lord. On 24, my lord, I will argue, my lord.
Yes, you are there for the...
Yes, my lord. If the matter can be taken up tomorrow itself.
Tomorrow I have problem, my lord. Tomorrow I have some on matter before Justice Chief Justice Court, my lord.
Okay.
So
Then,
day after tomorrow, my lord.
Then you have it on Monday.
Yes, my lord, Monday, my lord.
Because Friday is the last working day for this court. It will be difficult
Yes,
to
Monday.
take up the matter. 27th, Mr. S.K. Mehdi, learned counsel, learned CGC,
Yes, my lord.
appearing for the NF Railway as well as the
Respondent
respondent
5 and 6 in contempt.
Sorry?
5 and 6 of contempt, my lord.
Respondent number 5 and 6 in the contempt case submits that as he has some personal difficulties to conduct the case today, he prays for adjournment. Ms. Valentina Dinpui, learned counsel, appears for the petitioners in the contempt petition. Are you there in the writ petition also?
My lord, I am the respondent number 4.
Petitioners in the contempt petitioner in the contempt petition, and for respondent number 4 in the writ petition. As no objection, in view of above, list again on 27th of April 2026. This writ petition has been revived.
Yes, my lord.
Yes, my lord. Yes, my lord.
Earlier it was dismissed, it was revived again.
Yes, my
Yes,
lord.
my lord.
Okay.
Because contempt petition is pending, so my lord, it was dismissed, my lord. But I filed a court allowed to file a review petition, my lord. And there's some observation again, my lord. The review file, my lord, it was revived.
Okay. Don't seek adjournment next date. On
Yes,
Monday.
yes, my lord.
Argue on
Yes.
Monday. All right.
Yes, my lord. Yes.
May I seek your lordship's indulgence in mentioning item number 5 of hearing list?
5 of the hearing list.
Yes, my lord. As Mr. Priyanshu Goswami, who is the leading counsel for the respondent number 5, is having personal difficulties, my lord. If the matter can be taken up after 4 weeks.
4 weeks.
Yes, my lord.
Who's appearing for the other side?
Mr. Ramzawa is appearing, and he has already taken his consent.
Okay. Are you there in the case also?
No, my lord. Mr. Priyanshu requested me to mention on his behalf.
Okay. A prayer for adjournment has been made on behalf of Mr. Priyanshu Goswami, learned counsel for the respondent number 5 by Mr. Lomo Maralte, learned counsel, stating that as Mr. Goswami has some personal difficulties to appear before the court today, the matter may be adjourned for 4 weeks. So he submits that he has taken the consent of the learned counsel for the petitioners. In view of above, list again after 4 weeks on a date to be fixed by the registry.
I'm highly obliged, my lord.
For this item 23.
My lord, item 23, this is bail application. This is taken up by Ms. Van Isiambi, and she is out of station, my lord, on medical leave. So if the matter can come up in the next week, I have taken the consent of the other side. Yes, Monday, all right. Obliged. Obliged.
Item number 24.
May it please your lordship, may the matter be kindly passed over for time being, since the petitioner's counsel, leading counsel has just arrived this morning, and there has been delay in reaching Aizawl. So he's on his way.
My lord, in this case, CD was called for, but today I have not received the CD. If it can come up tomorrow, my lord.
Yes, my lord.
Item 25.
May it please, my lords. My lords, item 25 and 26 are connected matters. The last occasion the trial court records are called for.
Not yet, my lord.
My lords, on 7/4 it was ordered, and the matter was in fact listed yesterday. My lords, 7/4/2026 order was passed calling for the TCR, and the matter was fixed for yesterday, but due to the election it has been listed today. My lords, otherwise I've annexed the certified copies otherwise, and the only limited issue is on the grounds of arrest not being provided. So perhaps my lords will be satisfied from the annexures I've already annexed. That is the only limited issue, my lords. There's no need for perusing any further records.
My lord, the problem is, my lord, the trial is already ended. It's for written argument, and judgment will be pronounced within this week itself. So, and my lord, the petitioner's counsel has not approached the trial court even for bail. So they have not exhausted all the remedies. That was my first point at the motion stage. And since trial is almost ended, my lord, I think it will be better if he can approach the trial court, my lord, at this stage. Submission of written argument is tomorrow, my lord. Tomorrow. And judgment most probably by this week or next week.
My lords, the only issue here is, my lords, as she has rightly submitted, but my lords, the trial is not complete as it's a settled order until judgment is pronounced. trial is still ongoing, my lords. And the only issue is that every day the petitioner is behind bars. It's an illegal detention, my lord. Therefore, whether this constitutional court, being aware of this violation, would even allow him to be in custody even for one single day, my lord. That is the question before my lords. My lords, because my lords, in item number 26, he had already approached the trial court once. It was rejected. But in this matter, yes, my lords, he has not approached. Yes, my lords, he has not approached because, my lords, because he did not have the means. My lords, yes. My lords, the reason is that he comes from a very poor background, my lords. He was a truck driver and he could not afford any counsel to engage in a bail application. And it is. My lords, I'm afraid that they might pass the judgments, my lord. It's at the fag end. My lord, is it possible tomorrow, my lords? Because I have come all the way from Guwahati, my lords. It will be very difficult to again come back.
You can appear through VC. All right, ma'am.
My lord, could it be this fourth Saturday, my lord? It's working, I'm told. This fourth Saturday is working, I'm told. Could it be on the fourth Saturday? No. I think I came across a notification which said that because of the elections, in lieu of that day, yes. So, in that case, my lords, could it be on the Monday, my lord, 27th? 27th. And my lords, I have brought a compilation of judgments. Could it be a part of the record for my lords to refer on the next occasion? I'm so obliged.
Item 26.
My lords, same order perhaps. Yes, my lords. 27th. Obliged.
Obliged.
Admission, item 1.
May I please, Your Lordship? Your Lordship, in this case, the order have been complied. Judgment and order has been complied. In item number 1 only, Lordship.
Item 1 only.
Yes, Lordship.
What's your good name?
Lal Ropari.
Mr. Ropari, learned counsel for the petitioner. In certain cases, C number 16 of 2019, states that the judgment and order of this court has been complied by the government. Who appears for the opposition?
For respondent number 3, 7, and 9.
Mr. Sakri, learned CTC, appears for respondent number
3, 7, and 9.
3, 7, and 9.
Daniel Shassel on behalf of Miss Mary L. Kyungte. For respondent number 12.
Counsel appears for respondent number 11.
Yes, my lord.
Do be obliged.
Lordship, item number 2 to 16. It's not fully complied now. If you give 3 more week time, they can be completed. I feel that. 2 to 16. Yeah, together. 2 yeah, 2 to 6, same. Yeah, however, it's the same case. Yes, if you wait for 3 weeks, it may be completed. From DC side, yeah.
in the process of compliance. And if the matter is listed after 3 weeks, the up-to-date status will be clear
Yes.
by then.
Daniel Shassel, on behalf of Miss Mary L. Kyungtae, for respondent number
Lo- he
for
killed
respondent
the
number
man.
4, 8, 10, and 15.
He killed the man.
Item number 2.
Ai người lâu đi dùng bắt rồi.
Yes, Your Lordship.
Ừ.
Yes.
Lên dùng vậy như cái
Deputy Commissioner.
For respondent number 7, Your Lordship.
In which, I mean, in all the cases,
In all the cases, yes.
are you there in some of all the cases?
No, not all, Your Lordship. In item number 6, in some cases, I am respondent number 3.
But there are only item number.
Item number 2, number 3, number 6, number 9, 10, and 11, Your Lordship. 11 and 13. It sounds any.
Which one? Please again with the lordship. Yes, 12. 12 of May.
This is the matter, of 12 of May 2020.
Lordship, in the middle, I have not seen that. Item number 14 is different. This is WPC. Contempt, yes. Up to 16. Yes. Yes. 7 to 13. Yes.
Separately, 12 separately, 13 separately, 15 separately, and 16 separately.
Yes.
Those which are combined in screen. Which one will be common order?
Item number 17.
14.
14. sir.
Your wife was not 17. It was already adjourned. 17 and 18. Already adjourned. This is a part of matter.
Yes.
Let us complete the other matter. We will come back to this.
Fine, Your Lordship.
Item number 19.
My lord, the respondent number 1 and 2 service has been completed, but they have not been represented till date, my lord.
Respondent number 3.
What is your submission?
I'm praying for time for filing affidavit.
How much time?
3 weeks time.
The learned counsel for respondent number 3, Mr.
LS Laram Swana.
L.S. Nalgamswara. Is it in the process?
Yes, my lord.
My lord, if I may make one submission?
Yes. Praise for and it's granted. How much time?
3 weeks.
3 weeks time. Requires no first reply. Yes.
My lord, in the last order, 14/1/2025, the respondent number 1, 2, 4, 5, and 6 has been, it's written as Mr. Samuel has been representing the respondent number 1, 2, 4, 5, and 6. However, Mr. Samuel only represents number 5, 6, and the 7, all of whom have been discharged, my lord.
So there has been some error in the order. Yes. IA has been submitted by the respondent number 567, my lord. So they have been discharged on by order dated 18/11/2025 from parties, my lord.
So who remains now?
We only require the representation from the respondent number 1 and 2, my lord, whom have not been represented by any counsel.
Notice is complete otherwise.
Yes, my lord. Completed on 13/2/2025.
2025.
Yes, my lord.
When did you come?
Yes, my lord.
Last year.
Yes, my lord.
What is the order not complied with? Refunding of cess?
Yes, my lord.
Who are 1 and 2?
This is the chief secretary and the revenue, my lord. Secretary of government.
Are they still the, okay, 1 is still there. Number 2 is the secretary. As on date.
To my knowledge, yes, my lord.
But show me by which order or by which office note that notice is complete.
AD card returned, my lord, on the notice.
Where is that? On which office note?
Office note dated 13/2/2025. AD card from respondent number 1 and 2 has returned.
Office note dated 13/2.
Yes, my lord.
Correct. Yes, government, Miss Linda is there. Chief Secretary and the Secretary Revenue. We should inform them. We don't want to call them unnecessarily.
I'll inform them, my lord. I think
Please do that. Please use a good office and tell them that the case is pending. Somebody should appear. I'll fix it again on next Monday. Then you cancel the order. Miss Valentina Laldinpui, Learned Counsel, appears for the petitioners and submits that the remaining contesting parties, after the discharge of some of the respondents, are the respondent numbers 1, 2, and 3. Stop. Although AD card has returned back from respondent numbers 1 and 2 on 13/2/2025, as per the office note dated 13/2/2025, no one appears on their behalf today. Who stop? Mr.
Elias Lalaram Suana.
L.S. Lalaram Suana. Learned Counsel appears for respondent number 3 and prays for 3 weeks' time to file show cause reply by way of an affidavit. Next para, in view of above, list the matter. Again, after 3 weeks, stop. Mrs. Linda L. Fumble, Learned Additional Advocate General, is requested to inform the respondent numbers 1 and 2 about the pendency of this case. It is also made clear that if no one represents them, by the next date, court may consider passing appropriate order. All right.
Much obliged.
Item 20.
Yes.
Your Lordship, affidavit in reply to the affidavit in opposition of respondents number 1 to 5 will be filed during the course of the day.
Okay, so learned counsel for the petitioner submits that the rejoinder affidavit of the petitioner will be filed during the course of the day. In view of above, list this matter. After a week. Next.
Attempt approved 21.
May I please, Your Lordship? Lordship, in this case, the leading counsel has some personal difficulties, and I have taken the consent of the other parties, and if the
Leading
matter...
counsel Al Fakoma,
Yes, Lordship.
what happened?
He has some personal difficulties. If the matter can be kindly taken up next week, Lordship.
What is the matter? RFA?
Yes, Lordship. Against the order passed by the civil judge in Manisur 46 of 2020.
TCR has come.
No, my lord.
TCR has not come. I see. That's what I was asking you. You said no. Case is yet to be admitted. Notice has gone, but Mr. Lal Fakomal, learned counsel for the petitioners, for the appellants, he said to have some personal difficulty to appear before the court today, and therefore adjournment is prayed on his behalf. Stop it is also noticed that the TCR has arrived. Ms. Lomsangi, Rosie Lomsangi, learned counsel appears for the
Respondent, my lord.
for the respondent
So respondent.
and has no objection to the prayer for adjournment. Next para in view of above, list again when?
Next week, if possible, Lordship.
Next week when?
Any date.
Okay, let them give a date. List again in the next week.
Give me obligement.
Next.
Item 22.
My lord, I'm appearing on behalf of Mr. Caesar Ramsana. If the matter may be taken up next week. He was here, but he has some personal difficulty. He went home for that. So
Zoram Chana, C. Zoram Chana.
yes, my lord.
On a prayer made on behalf of Mr. C. Zoram Chana, learned counsel for the petitioner, matter stands adjourned. Petitioners S. Matter stands adjourned to be listed again in the next week.
Item number 14.
Lordship, that reference court order also I have done.
There's a reference.
In other cases, similar cases.
Others have gone.
Yeah. Other cases, not. Yeah, then last 4 days, my junior told me that to have a reference court order in a similar case.
Yes, my question was whether any reference was filed by the petitioners.
No.
And if no, then what about the others?
The others, they have filed and the order is there.
Total, I think we're concerned with Book Pui.
Book Pui, only Book Pui.
There are how many? There are 156.
Yes, yeah, from Serkan to Bakarot.
Yes, please give me. Please give me.
There's Eng Moya. This is
See, Serkan to Baga Road, there are many.
money.
It's all divided into various areas, isn't it?
Right, Your Lordship.
There are 5 petitioners here
Yes.
who are concerned with Buk Pui.
Yeah. Yes.
And for Buk Pui, there are as many as
100 something. Yes.
156, I think.
Yes. Round about that.
136.
Yes.
136. Now, who has gone in reference?
Reference gone in not from Bukpui. It's this case, this particular case, it's part is North Saltang village. That the same stretch of road. And
No, you have given me how many copies? 1, 2,
I think
3,
it's a continuation, Your Lordship.
4.
Same case. Now it's pending before this Honorable Court RFA. First, LA, 15 of 2015. That is reference court order, Your Lordship.
No, you tell me who has gone in reference?
Yes.
Who are the parties who have gone in reference?
Yes, this person also, and I have some of most of them are gone to reference court. And the reference court disposed the case, allowed them, and again they have filed for execution. After execution, attachment order also there. And after that, they have filed, the government have filed RFA against all the orders.
RFA?
Yes. Against all the orders, which was pending before this court. And this case, this particular case, is a continuation. Here, the reference court has passed order. Kindly see, Your Lordship, LA case number 15 of 2015. The order is in page 36. Lordship got it order. The claimants, namely Engmoy, shall be paid compensation that appear in the apportionment section of the award 3 of 2014, dated 23/4/2015 for damage caused to his house building. Your Lordship, this award number is an earlier award.
No, what has been awarded? I understand it's an earlier award.
Yes.
So against the earlier award,
Yes.
they have gone on reference.
Yes.
And the reference court has passed this order.
Yes.
What is the order otherwise? The amount has been enhanced?
Yes.
How?
Here, Your Lordship.
How much?
Your Lordship, claimant shall also be paid compensation that appear in the apportionment award number such and such. This is appeared to be VC pass. The court opined that 2 years multiplier is given, solicium is given, and in this case, the crops already apportionment made by the award number 3 was accepted. And the other case,
No, I fail to understand what kind of order is this. What benefit has the reference court given to the landowner?
the Lordship here, it's the previous award was accepted and not the reassessment award made by the government.
What is that assessment award?
Thing is the same award which was deducted in our case also deducted. They made a reassessment on the basis of this award. Verification, and they said that it's a decrease. The area of the land is decreased.
All
so
right.
they have made reassessment.
No, see, where is the question of the second award? Now, if this party, what is his name, Engmoya and
Yes.
this two person,
Yes.
they have filed reference
Yes.
under section 18
Yes.
against the original award.
Yes.
Correct?
Yes.
What was their demand? That the amount should be more.
Yes. The amount should be not in the reassessment, it should be in the previous award. Reassessment award is reduced, as stated in my petition in the WPC. That's why my prayer is in the present WPC that the amount already made in the award number 3 of 14 should be prevail.
Do you mean to say that these two persons have gone before the reference court
Yes.
after the reassessment was done?
Yes, yes.
Not before that?
Not before that, yes. Because the judgment is, Your Lordship, 2014, 24. And after the reference court has made this order, the petitioner gone for the execution, and execution court again direction was made and attachment order was made by the execution court.
The original award is dated 23rd of April 2015, correct? And the reassessment.
Yes.
And
Reassessment.
the reassessment award was made on which date?
The reassessment award was made in 2018, if I'm not mistaken, Your Lordship.
If it's in 2018, so
Yes.
how can the reference go back in time? This LA case is of 2015.
Yes, but
It
this
is not
order,
that it is not that the reference was filed after the second reassessment was
yeah,
done.
but the order is passed in 2024.
Maybe, but the LA case is filed in 2015.
Right.
So in the year 2015, there was no reassessment.
Right.
There was no reassessment.
I understand.
So on what
that.
basis this kind of order is passed?
Your Lordship, the thing is that in the meantime, there is a appeal in the previous award. So in the hearing is going on in 2024. So it's make known to the judge about the situation.
No, he should not be concerned with the what reassessment was done. That is not the outlook.
Yes, Your Lordship.
Because
here-
please listen,
Yes.
the original award passed in 2015. Party is aggrieved, they filed reference in 2015.
Right.
And when the 2015 reference is disposed of, this has a mention of the reassessed amount.
Right.
Where does there's no question of mentioning that reassessment amount
Your
at this
Lordship,
stage.
In my understanding, the case is disposed in the year 2024. So during the hearing, it is mentioned that there was a reassessment. Then the appeal was there.
Anyway, okay. We are not concerned with this. I was just curious why the
Kindly
reference was not
see
made.
para 11 of this reference order. It's mentioned here, Your Lordship, regarding the reassessment also. Para 11 of the page 33 of the LA case number 15. Mr. Riel Hata, Planet Counsel for the claimant, submitted that everything about the acquisition of land belonging to the claimant's damage to house building props, damage with amount of compensation assessed and to be paid to the landowner's claimant have been clearly mentioned in the award number 3 of 14 dated such and such. In support of his submission, he placed reliance on the order placed by the Guwahati High Court Aizawl Bench dated declaring the award number 3 of 14 dated was valid. He added that as the assessed value of the properties damaged by the true law, they claim enhancement by applying multiplier method by taking into consideration the prevailing market value of the properties. He further submitted that, here, Your Lordship, what I mean to say is that he made known to the court that there was appeal. However, it succeeded.
Appeal against what?
This is award number 3 of 2014.
Who filed appeal?
It's it was allowed by the single banks, then the government filed an appeal before this honorable court that the previous court, Your Lordship, your order is there. You and the other judge, division bench.
What is this WPC 10 of 2016?
10 of 2016 is that is this honorable court passed in the year 2016, whereby it's declared that award number 3 of 2014 is valid. And again, yes,
According to the respondents, the award was lapsed. But the court said that award is not lapsed. It is valid. Correct? WPC 10.
right.
Then against that, they
Against
filed
that,
appeal.
Yeah, they have filed writ appeal. And the writ appeal order is the writ appeal order is on dated 30/10/2024. Here it is stated that paragraph 14, at any rate, the direction passing WPC, this is, in the meantime, WPC 167 of 2017 was filed by some person. Order has been acted upon and that the same has not been questioned nor challenged by anyone, including the present respondent. In view of such development, the challenge made in the writ appeal has only been rendered redundant, if not infructuous. The respondent have raised the issue of the steps taken by the authorities to be known in terms of direction passing number 167 of 2017. However, the same in our considered view cannot be a subject to issue to be gone into the present writ appeal. In other words, the scope of the instant writ appeal in our considered view cannot be enlarged by taking into account what has transpired in respect of the issue raised in another writ petition, whether the same was decided in appropriate manner or not. It is, however, observed that the dismissal of the instant writ appeal would not mean that the respondent or any of the genuine landowners are debarred from asserting their rights and claims, which, however, should be in accordance with and as may be permissible in law. As we have come to the above conclusion, there will be no requirement to dwell upon the authorities relied upon by the parties. So, in this paragraph 14.
Okay, just a minute. Let me read myself. Okay, tell me, WPC 10 was allowed,
Yes.
saying that it cannot be lapsed, award is not lapsed. payment should be made.
Right.
Was anybody paid after that judgment? Or nobody was paid?
It was paid in accordance with the reassessment only.
Earlier assessment. No, after that, WPC 10, 167 of 2017 was filed
Yes.
by this, what you call, group of people.
It's not paid. And again, there is a 167 of the WPC was filed by some person, wherein this honorable court allowed them.
No, that I know. I'm asking you whether payment has been made in terms of WPC 167 or in terms of WPC 10.
167.
Anybody paid in terms of WPC 10? No one. 167 is to look into the faulty
Right.
thing and to make rectification.
Right.
So they came up with a reassessment.
Yes.
And those who accept, they were paid. Those who don't accept, not paid. You have accepted the payment without prejudice to your right to challenge the award. Now, that is the situation.
Yes.
Now, question is, has anybody gone in reference at any point of time? That was my query yesterday.
Yes.
No, day before yesterday.
Yes.
Today you have come up with this order
Yes.
of LA case number 15 of 2015, filed by two persons.
Yes.
This is not in respect of that particular area where you belong to, isn't it?
But the same stretch of road.
Same stretch of road,
Yes.
but not in terms of what is that area I call it? You call it? Bukpui. Okay. Now, during the pendency of this reference application, the reference court was informed that there is another reassessment also.
Yes. Because
So, if that is the case, this should have been disposed of, and they should have filed a fresh reference application as per the reassessment amount to see whether the assessment is correct or not. Instead, the reference court continued as if reference is made for the earlier award as well as for the subsequent award. This is something which I fail to understand.
yes, Your Lordship.
But at any rate, you have not filed any reference.
No, because
Why didn't you file reference?
This case is pending before receiving the reassessment amount. I have filed this case.
No, that I know.
Yes, that's why.
Why didn't you file a reference application in the first place?
Because this case is still pending, I can go to courts.
No, before,
cannot
instead of coming to this court, you could have gone in reference.
Your Lordship, the thing is that in the meantime, they have made reassessment amount. So we are those who are accepted only should be received. So we have approached this honorable court that on protest we have may be allowed to receive the amount on protest. So this honorable court was allowed.
No.
In the meantime, I have challenged 167 before this honorable court in this particular case.
167 means? What is-
167, which was directed to make out the faulty process.
You have challenged.
Yeah, I have mentioned here in this case.
No, you cannot challenge what is passed in the writ petition by way of filing another writ petition.
No, the thing is that in the meantime, without highlighting the previous writ petition order, they have made another writ petition 167.
But that is by different party,
Yeah, different party, but the same issue.
same issue, no doubt.
Yes, yes.
So
And
that is why this court has also observed in the writ appeal
Yes,
order
I
you
understand.
just read
Yeah, I read.
that government should have informed the court that earlier there was another order.
Yes, yes.
So where the court has accepted that the award should be acted upon within
Yes.
6 months.
Yes,
Nobody informed the court.
yes.
So the court say that, okay, you consider, examine and examine the faulty process
Yes.
and do the needful within a time frame.
Yes, that's why here I have mentioned that, Your Lordship, 167 direction is to process faulty process It's not directed to reassess genuine person land.
That I've understood.
Yeah, that is my statement in this.
That I've understood, Mrs. Dinari. My question still
Yes,
is that there was an award in 2015.
right.
You did not prefer reference because it was okay to you.
Yes.
You accepted it. But before payment could be made, one writ petition was filed, 167, wherein court said that you examined the faulty process.
Yes,
So after the faulty process was examined,
yes,
one reassessment was made,
right,
where the amount has been reduced now.
right.
So against that reassessment award,
Yes,
you could have gone in reference. That's what I'm saying, not against the original one.
yeah. Because, Lordship, why I approached this Honorable Court is that the direction made in 167 not to reassess the verification and reassessment was not direction. It's only faulty process. But
Correct.
in my case, they have reassess the amount. So because of that, I have approached this Honorable
I
Court.
understand that also, but you know that how many people were affected by that
I know.
reassessment. Here we have only 5 people coming saying that why reassessment?
Yes.
Nobody said that you should reassess. Why did you reassess? Only 5 people have come.
Right. Your
What about
Lordship,
the others? Where have they gone?
Your Lordship, the other are not decreased. Some are increased.
Are you sure?
Yes, I have stated in my petition here. So ours is not even half of the previous award. That's why we are aggrieved. And when they have disbursed reassess award, they made us to accept. However, you have approached this Honorable Court to accept on protest. So since the way they have processed is not correct, not in the direction by this Honorable Court, that's why we have come here. All of them are received the reassessment award.
Now tell me, as per the first award,
Yes,
some assessment was made.
yes,
Amount was fixed.
yes.
That amount is towards damages of crops
As
or
well
for
as-
land.
Yeah, right.
Which one?
Land and crops. Some are periodic pata, some are VC pass. Your Lordship, I
No,
haven't
if
made
you
the
see
chart.
if you see the chart which you have annexed,
Yes,
nobody except one has been given for land. The others are all for crops.
yes.
Please come to page 17 of your writ petition. This is the award prepared by the district collector dated 23rd of April 2015. Except for petitioner number 1
Yes.
in respect of periodic pata number 53 of 2006. Nobody has been given compensation for land.
No, no, Your Lordship, that is not correct. Kindly see
Oh.
para 9.
No, not what para 9. You come to page 17 of your writ petition. Page 17.
Yes,
Serial number 3, Lalyan Tluanga Book Pui. He is
Yes.
petitioner number 4.
4, yes.
Where do you see that he has been given compensation for land?
No, this is VC pass.
This is only for value of crops.
Yes,
2,06,500.
right,
Correct.
right.
Turn the next page.
Yes.
Page 18.
Yes.
Serial number 13 is petition number 2.
Periodic pata.
Whatever pass may be, but there's no, look at the column. Column
Yes.
number 1, 2, 3, 4.
Yes,
Area of land acquired. There's nothing. Total
Yes.
land value, nothing.
yes. They
So-
have admitted that mistakenly they have not added in their affidavit.
No. You see,
Yes.
you have no complaint with regard to the first assessment.
Yes, yes.
Today, you are claiming that give me compensation as per the first assessment.
Right, right.
What I'm saying is that as per the first assessment, there is no compensation for land given to you. This is all for crops.
No,
Except
two of them. Two of them.
one. I'm coming to that. Only one of them. Except for petitioner number 1 in respect of his periodic patta number 53 of 2006,
Yes.
an area of 106,524 square feet,
Yes.
for which he has been paid 15,97,860. Except for this petition number 1, for one of his land, nobody has been given for
Below is page
land.
24. Page 24.
24 also, it's for petition number 5, Pasena. There is no amount of land, value, area of land given. Straight away, it's
Straight away they have amount.
straight away
is there.
it says value of crops.
Yes.
So you go by this assessment only.
Yes.
That is why you are before this court.
Yes. The
Give
lordship-
me the compensation as per this first assessment.
Yes.
That is what you're saying.
Right.
And you must accept the fact that except for petition number 1, nobody's land has been acquired. Only for crops you're getting. So, as per the reassessment, let us see the reassessment.
Yes.
What is provided now in the reassessment? Again, this also says crops. Page 36.
Yes.
Miss Lal Nunlu, you also turn the pages whenever I see. I'm going to question you also. Page 36 is the second assessment,
Yes.
reassessment you call it.
Right.
So the fourth column is only for amount payable for crops, etc. So nowhere here in this column is mentioned about payment for
Yes.
land. Now column number 5 is solatium, number
Interest.
6 is interest, like that. Solatium and interest is different.
Yes.
That has to be a part and parcel of the award, correct?
Yes.
We are concerned with the figure of on crops.
Yes.
Initially, as per the first assessment, petition number 4 was awarded 2,06,500. Now it has been reduced to 1,46,000. Let us concentrate on this issue only. Petition number 4.
Yes.
From 2,06,500, it has come down to 1,46,000.
Yes.
Now, question is how they have arrived this. This is a big question, Ms. Lalnunlui. You'll have to answer this. Because reassessment was done in the year 2018. First assessment done in 2015. After 3 years, whether the crops are still visible or not, how they have counted, what is the method that you have utilized. On the other hand, you say that nothing is visible anymore. Do you still retain a part of the report, verification report?
It is in my office if it's required.
It's in your office. Why didn't you bring it?
Your Lordship,
You think you'll get lost or something if you bring it? See, you have given me one record wherein it says that the original record is with you as regards the verification report.
Yes, Your Lordship.
This basically does not contain much. And there are certain inconsistencies also. Now, you see, out of these claimants, how many bogus claimants was identified? 136 or what?
167, Your Lordship.
167 bogus claims. Does it include the 5 petitioners?
No, Your Lordship.
It does not include.
No, Your
If it
Lordship.
includes, their name would not figure in this reassessment. So how have you reduced this amount? If you cannot count the crops, can you count the crops after 3 years? What was there in 2015, will it remain in 2018? That justification is not there. in your entire file. I've gone through entire file. Crops, they are not trees. Trees will last 100 years. But crops, this fruit, that fruit, you don't know. After 1 year, it will just disappear. Yet, you have now made an assessment as 1,46,000. On what basis? Now, let us come to petitioner number 2, Chuam Luna. He was given 3,55,950. Now, he's given 1,55,000 for crops. More than 50% has been reduced. On what basis? Then, if we come to petition number 1, Bil Alzom Liana. He was getting 29,58,000 for crops. Now he's getting only 9,86,000 plus 1,16,000. And what about the value of his land? Not given. And you have, Mrs. Dinari, you see the affidavit of the respondents. The last affidavit. Last and the second last affidavit. You also turn to that affidavit, Ms. Lalunlui. I would like to know from where have you got these statements. Let us go to the last affidavit dated 11 March 2026.
Yes.
Now, if you kindly come to page number 7.
7.
Both of you.
Yes, I got it.
This is regarding petition number 1.
Yes.
Original award is 29.
Yes.
Revised award 9.
Yes.
Difference in rupees is 19 lakhs.
Yes.
Amount paid with solatium is 1659. This is under protest.
Yes.
Now, reason for revision.
Yes.
Ms. Lalunlui, come to page 7 of your additional affidavit.
Yes, Your Lordship.
Page number 7, you've got it?
Yes, Your Lordship.
The last column, reason for revision. Please read that.
Crop count reduced on ground verification. Original assessment included crops on areas not actually damaged. Road alignment changed. Revised count based on physical inspection with landowner and VC present. And the second paragraph is...
No. Let us stop there for a moment. So, from where do you get this? On ground verification. Ground verification was done 3 years down the line. 2015 verification was done, amount was fixed.
Yes,
After 3 years, again one verification, amount has been reduced drastically. Where do you get this in the verification report? Which you have kept in your office. Where is the verification report? You have annexed it. You have also annexed it in this affidavit.
Yes, Your Lordship.
Page 24.
Yes, Your Lordship.
Reason for revision, is it available in the verification report?
No, Your Lordship.
Then, from where did you manufacture this? See, what I'm saying is that if you have followed the court's direction to look into the faulty position at that time, you should be specific for each and every land. We have gone to this land, this is not there, that is not there, this is not there, hence this much. That should be reflected in the report.
Yes, Your Lordship.
Only the figure is changed, that's all. From this amount to this amount. How it is changed, we don't know. And now you come with an affidavit saying that this is the reason. Can it be accepted like that? Because affidavit cannot improve your case. Affidavit is something which is taken out from the records.
Yes, Your Lordship.
So since we are not satisfied with the affidavit, we wanted to see the records. You brought us the records. The records does not reveal that number of counts of crops has drastically reduced. It cannot be this much, and this area was taken earlier. It was not to be taken. All that. Nothing is there except for this affidavit wherein you prepared a chart. The contents of the chart is not available in the report itself. So it does not justify the reduction. As simple as that. Primarily, the persons came before the court and with that WPC 167, correct? What? 167. Saying that there were some bogus claims. Some people who are not supposed to receive are receiving all that. That kind of allegation was made. So now you have refined the genuine claimants and the bogus claimants. The present 5 petitioners are not bogus claimants. They belong to the group whose lands are affected. And now you've reduced the amount, saying that, no, this much was not the crops. After 3 years, you rediscover that the crops were less. How is that possible? Is it humanly possible? Had it been like sort of a teak plantation, some mango groves, and whatnot, which will last for years and years, then it can be understood. But there's no definition of crop count also. What kind of crop count? The details are not there.
Your Lordship, the statement made in
So this is the difficulty I'm finding. I've gone through the records. I've gone through the brief of the writ petitioner as well as your counter affidavit. But that answer is not there. But at the same time, I want to know what has happened to those persons who had gone in reference. Reference also, they started in 2015. It was somehow, it carried on till it was reassessed in 2018. And after reassessment in 2018, ultimately in 2024, the reference court says that the original assessment will prevail, as if he's deciding between the first assessment and the reassessment. That is not the job of a reference court. Anyway, nobody has challenged that. I'm just thinking loud. Yes, Mrs. Dinari, what do you want to say?
Your Lordship, the affidavit submitted by them and the letter by the subdivisional officer, deputy commissioner, stated that they cannot verification team could not verify actual. Almost all the acquired area and numbers of crop planting have already been wiped out during the spot verification. So how can they say that?
That was a letter.
A letter, yes. They admitted that they cannot do exact.
Right, you had pointed out
Yes.
earlier also.
Yes.
This was a letter written to you, Mr. Nandui.
Yes,
Yes.
You have a copy still? 17 March. As per information received from the then member of the verification team, almost all the acquired land and numbers of crops plantation have already been wiped out during the spot verification. As a result, assessment of actual land area and number of damaged crops could not be determined, as the land in question is already devastated by the execution of construction works, then therefore I would like to bring to your kind notice that there are no original records or documents. So crops also wiped out, original records also wiped out.
Yes.
I would like to bring to your kind notice that there are no original records or documents which justified the revised award, and no further spot verification reports covering the physical area of land crops assessment of damage, except report submitted by the fact-finding verification team on Serkan Bagaland. So, a lot of contradiction with what your report says. Your report says that this is what has happened. We reduce the amount. And yet the instruction says that everything had vanished. You can't see anything there now. So on what basis was it prepared? And your affidavit of 16 December 2024
Yes.
also says that based on the verification report, paragraph number 4, based on the verification report, assessment for compensation was made for the exact area damaged crops to be acquired for construction of road. In the original award, area acquired reflected as 151 kilometers, whereas in the revised award, areas acquired reflected as 241,286.88 square feet. How do you convert this into kilometers now? 151 kilometers at one hand and 241,286.88 square feet. You have a converter.
And second para, Your Lordship.
Just note this. 241 286.88 in kilometers. Square feet in kilometers. How much will it be?
It's a square feet, it should be square kilometer. Kilometer pang.
No, it cannot be.
Kilometer pang.
Entire Mizoram is not that kilometer, 2 lakh square kilometer also.
Kilometer pang, ano square kilometer. And the second paragraph, it says, the area of the land instant petition are also reduced, and since the area is reduced.
Crops also reduce automatically. Okay, it is possible.
73.54424,102 kilometers.
70?
3.
Point?
0.544
Okay.
102.
We can round it up, 73.55.
Right.
73 kilometers, 73 and a half kilometers.
Yes.
From originally it was 151.
Yes. That is there.
Or make it 74. 11 minus 4, 7. 14 minus 7, 7. So, you reduce into half.
I don't know this is correct or not. The statement only. Not.
No, that's what.
Yes.
Ms. Lal Nunlui.
Yes, Your Lordship.
So, if this is your stand, it should be also there in your verification report. Land was taken, this much land was taken, assessed for assessment, but ultimately it was found that affected portion is only this much. So this much amount calculated with the number of crops will be this much. So amount is now this much. That would have been presentable, but now just modifying the amount. From 3 lakhs, you come down to 1.5 lakhs. From 3 lakhs, you come to 1 lakhs. How do you explain that? The records does not reveal that. Mrs. Dinari, anything more to submit?
Lordship, from my statement.
Then I'll hear
that-
Mrs.
Yeah.
Miss Lalnun Lui, and then we can think of closing the matter.
My point number 1 is that, Lordship, the award 3 of 2014 was made, and which was accepted by this Honorable Court. In the meantime, 167 of the PPC was filed, whereas the direction 167 of 2017, the direction is to identify the actual affected persons and to disburse compensation accordingly, and the said direction has not been put through challenge. The same had attained its finality. There is no question of making fresh assessment whatsoever to those affected persons. Therefore, the action of the respondent authority in making new assessment could not be held sustainable in any manner. So in this case, a Lordship, reassessment was made, saying that on the basis of the order of 167 of 2017. There is no direction at all.
There's no direction, but see, faulty process is there,
Yes.
mentioned.
Yeah, right.
So reassessment is the result of the discovery of faulty process.
Yes, we are not.
Supposing there is a faulty process,
Yes.
then the original amount cannot be sustained.
Yes.
That will have to be modified.
Yes.
If you modify it, that means reassessment.
Lordship, beside that, its direction was that it is stated that those who are genuine persons should be disbursed within such and such date. The direction is that we are genuine affected person.
Direction by whom?
Yes, by 167.
167.
Yes. Lordship got it?
Where is 167? You have annexed it. Oh,
Yeah, I
yeah.
have annexed, Lordship. Annexure
167
5.
where?
5.
Where in
Page
167?
32. 167 of 2000.
Which paragraph?
Page 32.
Paragraph.
Para 8, page 35. Lordship, in the bottom, subsequent disbursement of the compensation to the affected person within a period of 2 months from the date of receipt of copy of this order.
You read from keeping in view the statement.
Yes.
Fourth line from the paragraph 8.
Yeah.
Keeping in view.
3, 4, 5. Yes.
Keeping in view.
Yes.
Read.
Yeah. Keeping in view the statement made in the affidavit of opposition and the grievances of the present petitioners, the writ petition is accordingly disposed of with a direction to the respondent to take into consideration the faulty process which advertently crop up in the final compensation list and complete the process both for identification of the actual affected person and the subsequent disbursement of the compensation to the affected person within 2 months from the date of receipt of this order. So in my understanding, Your Lordship, we are not bogus claim, we are genuine. So why should they reassess my land?
No, they don't say you are bogus claimants. They just say that it was, they have made the assessment excessively. and some of the lands was not affected. This is what they say.
Yeah.
But then that has not been justified
yeah,
by the records.
yes, it's not justified. They have not.
If it was justified, then perhaps we could
Maybe.
we could have considered, yes, modifications required.
Maybe, Your Lordship,
But
that
there's
is-
nothing to show that this
no-
much has been reduced,
Right.
this much has been affected. This is the measurement, or this is what crops which have been not affected, which has to be deducted from the original assessment.
Yes.
If those details were available, then I think they would
understand
have been
that, yeah.
justified.
Right. Because even in their letter, it's admitted that they could not verify. And with regard to petitioner number 1, Your Lordship, verification was done in his past 2 times. First, before award, and just before giving, passing award number 3 or 14. It was verified again, and it was found that it is genuine. I have stated here, and even they admitted also with regard to Lalsumliana, the area of the damage area. So, without basing any record or any verification, they just deducted the area as well as the amount of the petitioner number 1 and petitioner number 2 to 5 without explaining any. They have just deducted. They admitted that even though with regard to Tuam Luna, you have not made, even though he's passed his periodic pata, you have not given land value. They have admitted.
Okay, one more thing which I almost forgot. Page 11.
Yes.
Ms. Lal Nunli also, please look at page number 11 of your additional affidavit,
Additional.
dated 11 March 2026.
Yes, Your Lordship.
Petitioner number 4 is given nil.
Yes.
But your reassessment says that he is supposed to get how much? Reassessment, where's the reassessment? Petition number 4. Reassessment. I think it's at page number 36 of the writ petition.
Read petition.
Lalian Tluanga.
Yes.
His petition number 4.
Yes.
He has been paid 1,46,000.
Actually, 3 periodic pata. Petitioner number 1, 2, and 5. Petition number 3 and 4 having VC pass.
Are you at page 11 of the additional affidavit?
Yes, Your Lordship.
Yes.
How much is he given? 0.
0.
And if you come to page 36 of the writ petition, he is given 1,46,000.
Yes.
So is it not contradictory?
It's contradictory.
On one hand, you are paying him 146 compared to the original award.
This is a solution. Yeah.
Original Solatium.
Solution. It's not.
No, it's not Solatium. It is the crops 146.
Yes, 146.
1,46,000.
Yes.
Solatium comes to 43,800. 12% interest comes to 55,872. Total petitioner number 4 is getting 2,45,672.
Right.
But in the affidavit, he's getting nil.
Yeah.
Hmm?
It's not tally with the actual.
So
award.
there's some discrepancy. And anyway, I already pointed out,
Yes.
on what basis are you mentioning, giving this remark, reason for revision? So this is something which has been spelled out in the affidavit. It does not come from the record. Can it be accepted? Petitioner number 4 originally was given 2,06,500, which has been reduced to 1,46,000. Anything else to submit?
And one more point, Your Lordship, affidavit filed by the state 16/12/2021.
16.
Paragraph number 2. Yes.
Yes. 1612.
Got it. That
Yes.
as the revised award was made as per verification was approved by Mizoram, approval was conveyed, such and such. Yes, one more, not in this petitioner number. I'm sorry, Your Lordship, it's a file on 25/8/2021. Paratri.
25 8
8
of
2021.
yes, paragraph number
3.
yes.
I say that P. Pata number 2229 of 2019 in respect of Tuam Luna as land value was not given and the revised award needed some correction and deputy was requested to submit correct revise. So they admitted that they have not given periodic Pata land value.
From Lunais petition number 4.
Yes. 2. That's it.
Nobody's given land value except for Bilal Zomliana as per the original award.
Yes.
Collector and party have done bad job. They have done a very
Yes,
bad job.
Yes, that is.
You have to face the
And
consequences.
para 6 also, I say that para P. Pata 168 of 2008 in respect of Pasena, an area of land was reflected in the revised award. Land value and crop were given, but it's actually not seen.
All right.
Yes.
We'll close the matter. Please write. Heard Mrs. Dinari Tiazu, learned counsel for the petitioners, and Ms. Lalnun Lui, learned government advocate for the respondents. Next para, the petitioners, who are 5 in numbers, have filed instant writ petition claiming that they are the genuine owners of their respective land located at Bukpui village within the district of Kolosip in the state of Mizoram. Construction is done by whom? Road construction?
PWD is our.
Your Lordship, if I may, at this stage, I would like to mention that the LA cases number 22, 23, 24 of 2015, wherein the reference court had passed order dated 17/4/2017. Sorry, Lordship, order was passed on 07/4/2017. The a revision petition has been filed, Your Lordship, challenging as to how did the reference court initiate the.
It's okay, let them challenge.
Yes, Your
Let you,
Lordship.
you challenge, no problem.
Yes, Your Lordship.
We're not concerned with that.
Yes, Your Lordship.
That is by some other people.
It is by the
Pet-
state.
Petitions have not gone anywhere.
Yes, Your Lordship.
Have you challenged the order passed by this court in that WPC number, that faulty process thing? Nobody has
No, Your
challenged.
Lordship. Nobody has challenged that,
Oh,
Your
that's
Lordship.
what. Then what did I say? Hmm. So the nature of land holding of the petitioners are either by way of periodic patta or by way of village council passes, which has been issued by the competent authority. Stop. The state government in the public works department has undertaken the acquisition of land measuring 115.20 kilometers in length for upgradation of Serkhan to Baga Road under the provisions of the Land Acquisition Act, 1894, open bracket, LA Act, close bracket, full stop. As a result of the proposed upgradation of the road, the land of the petitioners, amongst others, apart from other similarly situated persons, have been affected. And as stated earlier, the land of the petitioners fall within the Bukpui village. Which has been earmarked as Part F, Bukpui village, by the land acquisition, by the district collector concerned. Who stopped the district collector upon completing the formalities as required under the LA Act, came up with draft award number 3 of 2014 for Part F Bukpui, and the assessment was to the tune of rupees 2,57,25,966. Signed by the district collector himself on 23/4/2015. Next para. As per the draft award, the petitioner number 1 in respect of his periodic patta number 53 of 2006 has been assessed for the value of crops to the tune of rupees 29,58,876. Stop. In respect of his land covered by periodic patta number 53 of 2006, the area of land to be acquired was shown as 106,524 square feet, and for which a sum of rupees 15,97,860 was assessed towards land value. Stop. In respect of petition number 2, who possess periodic patta number 229 of 2009, a sum of rupees 3,55,950 has been assessed towards the value of crops. Stop. In respect of petitioner number 3, who is holder of Village Council Pass number 6 of 1994, a sum of rupees 4,83,016 has been assessed towards the value of crops. Stop. In respect of petitioner number 4, who is a holder of Village Council Pass number 29 of 2007, a sum of rupees 2,06,500 has been assessed towards value of crops. Stop. Lastly, in respect of petition number 5, who is the holder of periodic patta number 168 of 2008, a sum of rupees 1,53,254 has been assessed as the value of crops. Stop. The draft award was conveyed to the state government in the revenue department, and the same was approved. Along with the remaining parts, apart from Part F book pui. And conveyed to the district collector cum deputy commissioner Kolasip on 21/5/2015 by the Under Secretary to the Government of Mizoram Revenue Department. Through her letter under memo number K stop 12011/30, comma, not comma, slash, after 30 slash, okay, 11 dash REV slash PT dash Roman 1. Stop. However, in respect of the petition number 1, it was mentioned in the said letter that the assessed amount in favor of petition number 1 was omitted for want of clarification. Where is that clarification? Mrs. Dinari? Clarification for petition number 1.
Yes.
I've seen it somewhere.
Yeah, yes, here, Your Lordship. Para 4, Annexure 3. Annexure 3.
No, Annexure 3, that's what I'm saying. It was withheld for want of clarification. Later on, it was clarified.
Yes.
By which communication?
Annexure 3 of the writ petition.
I think Annexure 4. It is the case of the petitioners
Yes.
that subsequently
3 and 4, yes.
the Deputy Commissioner, Kolasip District, write his letter dated 4/7/2016. Written to the Under Secretary to the Government of Mizoram, Land Revenue and Settlement Department, clarified that the claim of the petitioner number 1 was verified on the spot and the assessment was done and the same was found to be genuine. Stop. That the amount so assessed, that is rupees 45,56,736, was found to be correct. Stop. Next para. While the petitioners were expecting payment of the compensation that was assessed, the respondents contemplated re-verification of the claim in view of the order passed by this court on 19/3/2018, in WPC number 167 of 2017. Stop. Be it stated herein that the said writ petition was initiated by what is the name of this coordination committee? Serkantu Baga.
Yes.
Initiated by Serkantu Baga Coordination Committee, which claimed that in the construction / widening of Serkan to Baga Road, there were certain false claims made, while genuine affected landowners were deprived of the compensation. Stop. Taking into account the grievances of the petitioners in that writ petition, a coordinate bench of this court, by order dated 19/3/2018, disposed of the writ petition in the following manner. Page 35 of the writ petition. Okay, page A to A. Next para. While the above was the direction of this court, the present petitioners contend that the respondent authorities concerned has embarked into recalculating and reassessing the compensation to be paid, which otherwise was not the direction of this court. Stop. The petitioners contend that they are the genuine land owners of the respective land, and their lands have been affected by the construction of the road. Stop. Therefore, the respondent authority concerned could not have made the reassessment and thereby greatly reducing the amount of compensation without any justification whatsoever. Stop. It is the contention of the petitioners that upon the reassessment being made, the respondent authorities concerned decided to disburse the amount of compensation only to those who have accepted the same. Stop. However, this court granted liberty to the petitioners to accept the awarded amount as per the reassessment of compensation without prejudice to their right to claim for compensation as per the original award. Of the learned counsel therefore submits that the petitioners received the awarded amount as per the reassessed rate under protest and without prejudice to their right and claim for the compensation as per the original award. Next para, Mrs. Dinari, Tiazu Learned Counsel, submits that while the amount of compensation to be received by the petitioners have been drastically reduced, but in most of the but in respect of most of the landowners, there either has been no substantial change or increase of compensation compared to the original assessment. And therefore, that might be the reason as to why others have not approached this court. Stop. At any rate, the learned counsel submits that since there was no direction from this court in WPC number 167 of 2017 to make reassessment of the amount of compensation. The respondent authority concerned could not have made the reassessment. Reducing the amount receivable by the petitioners as compensation. Stop. Secondly, there are no justifiable grounds under which the amount has been reduced. which can be clearly seen from the reassessed calculation statement. Annexed to the writ petition as Annexure 6. Stop. She submits that no reason has been shown as to how the assessment was made and why the amount was reduced compared to the original assessment. Stop. She therefore submits that the petitioners should be given compensation as per the original assessment made by the district collector on 23/4/2015 and which was approved by the state government as well. Next para. Anything else you want to add?
Lordship, even in the affidavit, with regard, in respect to petitioner number 2, even though he has a periodic pata, land value was not given, they have admitted.
No, land value was not given to you
Yes,
as per the original award also.
yes. They have admitted in affidavit that it's a periodic pata. It should be made. Here, the affidavit correction and the deputy commissioner was requested to submit corrected revised. So that means they have admitted periodic pata value was not given. They have admitted just a note that they have admitted that they are not given.
Which affidavit is that?
Lordship, it is in 25/8/2021, para 3.
The learned counsel, Mrs. Diazu, has also submitted that the respondents have clearly admitted at paragraph number 3 of the additional affidavit filed on 25/8/2021 that in respect of the periodic patta of the petition number
True.
2, land value was not given, and that the revised award needed some corrections. To stop, the Deputy Commissioner, Kolasip District, was therefore requested to submit corrected revised award. So where is the revised award?
They've not made till date.
Stop. She submits that despite such a stand taken, there is no revised award by which the petition number 2 has been granted compensation for the value of his land. Stop the learned counsel thus submits that under the facts and circumstances of the case, the respondent authorities should be directed to pay the compensation as was assessed by the district collector on 23/4/2015, less the amount which has already been granted, which has already been paid to the petitioners. So the remaining I'll complete later on.
Yes.
I think I'll keep it as CAB. It's better. Beginning part, you say hard so and so both sides. Okay. Hearing concluded. Judgment reserved. Huh? Second half, we are sitting DB first. And I don't think there's any single bench left.
No, it's left the unlisted mention.
Huh?
Unlisted mention.
Oh, unlisted.
Yeah,
Unlisted will be after DB.
And one hearing item.
We'll see. We'll see if time permits, okay?
2 p.m., my lord.
Yes.
Lordship will take up the unlisted motion at 2 p.m., my lord.
Yeah, not at 2. We'll have division bench first. There are 2 matters listed for today. So immediately after DB, I'll sit singly again and take up the unlisted matter.
My lordship.
Lordships, if I may mention item 2 of today's list, my Lords. It's for fix for hearing. My Lords, the learned government advocate Ms. Vani is out of station. So, my Lords, we are hoping that, my Lords, your Lordships may list it on another date. Hopefully next week, my Lords.
What are you challenging?
My Lords, the recruitment, the rules for promotion, my Lords.
309 rules.
Yes, my Lords.
If it's a 309 rule, we were just wondering, I think notice has to go to the Advocate General.
Yes, my Lords, that was kept, that was taken note of in the initial stage of the proceedings, my Lords. And so it went through, my Lords, the office. That is the instruction we have.
Was it issued? Let us see the file.
Yes.
I don't remember seeing. Huh?
That's the file. So sorry.
Item number 2. Where are you, Mr. Courtmaster? Appropriate bench. Then there is a mention, yes, no doubt.
Yes, my Lords.
But I don't know, perhaps notice should have gone straight away directly to the AG and separately notice to the other respondents 1, 2, 3, 6 and all that.
My Lords,
Isn't it, brother? Have you seen this? Notice be issued to the state respondent 1, 2, 3, 4, and 6 through the AG. Notice issued to the state and also to the AG. It should have been like that. I mean, to my understanding. You can do it. So we'll issue notice to the AG. This order says that it should go, notice should go to the state respondents through the AG. What we are talking about is notice to the AG. Let's see, these are the rules, 309 rules being challenged. We need your assistance in this matter.
My Lords,
I think even same thing with the central government. If you go through orders 27 capital A CPC, notice goes to the Attorney General or to the Advocate General, like that. What's this? CPC? Oh, it's here, it's okay. Suits involving substantial question of law as to the interpretation of the Constitution or as to the validity of any statutory instrument. Notice to Attorney General or to the Advocate General. Order 27A. So we'll issue and when do we have it?
my Lords, if it could be returnable by next week, it's a small.
AG is coming next week? Anyway, notice will go to him, but next week will be too short a date. We'll have to give him at least 2 weeks' time.
6th of May, my Lords. 6th of May.
6th of May?
7th. 6th of May. 6th is Wednesday, my lords.
All right. Mr. Jordan Roaming Thanga, learned counsel appears for the petitioner. And Miss Emily
El Sangte.
VL Sangte.
El
Only L. Emily L. Sangte, learned counsel appears for respondent number 5.
Yes, ma'am.
5 or 7? This is a private respondent, isn't it?
7, my lords.
Sorry?
Respondent 7.
Seven. Private respondent number 7. And who else? Mr. Samuel Valarthi Sangte, learned additional AG, appears for the respondent numbers
1 to 6.
1 to 6.
I'm
CGC.
sorry, 5 is, my lords, the MPSC. So 1 to 4 and 6.
1 to 4 and 6.
Yes, Madam.
And who's for the MPSC?
My lords, Mr. GC Standing Counsel. I don't know.
But he's not here today.
Yes, Madam.
Though, my lords, though they have said that they're not filing any reply to the petition, I'll just mention. It's come in the orders.
So we'll not say anything
Yes.
if they are not there. Please write, by filing this writ petition, the petitioner has challenged the relevant provisions of the Mizoram Urban Development and Poverty Alleviation Department, open bracket, group capital A within single inverted comma, posts, close bracket, recruitment rules, comma 2008, comma, more particularly schedule to the said rules for the post of chief town planner. To stop, according to the petitioner, the said provision is contrary to the provisions provided by the Mizoram Urban and Regional Development Act, 1990, which defines a qualified town and country planner under section 2 bracket Roman, small Roman 31. So, since the rules of 2024 have been framed in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India, comma, a notice to the Advocate General, Mizoram, would be required. So we have noticed that although notice was issued to the state respondents numbers 1, 2, 3, 4 and 6 through the Learned Advocate General, Mizoram, provide order dated 16/7/2025, the same would not meet the requirement provided under Order 27 capital A of the Code of Civil Procedure. Stop. We therefore deem it appropriate to issue notice to the Learned Advocate General, Mizoram, in view of the challenge made to the rules framed under Article 309 of the Constitution of India. The notice is made returnable by 6th of May. Stop. Mr. Samuel Valarthi Sangte, Learned Additional Advocate General, appearing for the state respondents today, shall apprise the Learned Advocate General about this order, so that necessary steps can be taken as may be required. List again on 6th.
Okay.
Admission, item 1.
This is
Lordship,
that-
I am appearing for respondent number 12 in the matter on behalf
Yes.
of contractor.
So where
I
are
have
you
filed
appearing
my-
from?
From Lunglei, Lordship.
Lunglei.
I have flight at 4 o'clock. Yes,
You-
I have
This
flight
morning you
at
said you were
4
catching a
o'clock.
flight. You
Yes,
have
yes,
proceeded
Lordship,
further
yes, Lordship.
south. Huh?
No, no. I have flight at 4 o'clock, Lordship.
You have a flight at 4
so I
o'clock.
have- Yes, Lordship.
How do you intend to catch a flight of 4 o'clock from Lunglei?
Because I'm near airport. I'm near airport itself, Lordship.
But you said you are in Lunglei.
Uh,
Langpui, I think.
Langpui,
Lang-
Langpui, Lordship. Langpui. Sorry. Langpui.
Okay.
So, Lordship, I have filed affidavit. In terms of the last direction, I was supposed to submit whether any limestone is being used in the contract and what are the progress of the project. I have filed the affidavit stating that no limestone is being used in the project. And
Yes.
apart from that,
On what basis are you stating that there is no limestone used?
Lordship, first, it
On-
is
on-
my affidavit.
On physical verification.
Because I am the contractor, I am executing the work, and the authority has also submitted. My employer, they have also submitted the affidavit stating that it is not being used. So NHIDCL, they have also filed an affidavit in this regard.
Okay, where is your affidavit? Okay. See, as per the last court date, you were supposed to tell us as to
Yes,
whether
Lordship.
limestones have been used for the construction of the road, firstly. Secondly, how do you intend to complete the entire stretch of the road within the time given to you?
Yes, Lordship. Yes, Lordship.
And,
Lordship, kindly.
And was there any other requirement apart from these two?
No, Lordship, nothing.
Okay. Then what
Lordship,
have you?
in case para 6 of my affidavit, Lordship.
Para
Para
6.
4 my affidavit. Para 4.
You are,
Page 6,
you are respondent number 11 or 12?
12. Yes, Lordship.
You are 11 or 12?
12. Contractor.
12 is the contractor.
Yes, Lordship.
Okay. Paragraph number?
Paragraph number 4 at page 6.
Okay, no limestones are used.
Yes, Lordship.
What stones are you using then? It is okay to say I'm not using limestone, but what stone are you using?
I'm using the aggregate from the picture.
Where is the statement to that effect? All that you say is that limestone is prohibited.
Yes, Lordship. Just give me 1 minute, I will inform that. And apart from that, Lordship, in para 5, I have also mentioned that whatever the work I am doing it as per the specifications of the mold.
No, somewhere you have mentioned regarding materials procured from Thenzol and other places. Where is that?
Yes, Lordship.
I have seen somewhere.
My lord, it's in the affidavit of the NHIDCL, my lord.
Oh, NHIDCL.
At page number 12.
Why? There are
Lordship, we are using aggregates. I have received the instructions that no limestone is being used. Upon physical properties of aggregates, we are using that. And the routine test is also being done. We have also operational field laboratory test at this site.
Where is that Thenzol? Project B, Thenzol Stone Quarry. Approved source aggregates for project A is Chiri River, Silchar, bed materials, and project B is Thenzol Stone Quarry. This is from where? This is where they're procuring the materials, is it?
Yes, Lord.
You have been given a copy of the affidavit filed by the respondent number 7 to 10.
Yes, Lord. Sir.
So out here the authority engineer has given a certification at page 12. Materials from Chiri River, Silchar and Thenzol Stone Quarry. Okay, and you say that there are no limestone being utilized.
Yes.
Okay.
Lordship.
Now you
Yes,
have
Lordship.
given us a chart here. Progress as on today.
Yes, Lordship. Chart is with regard to progress.
See, the signal from Lengpu is very bad.
Lordship, there are reasons I will explain it.
So in between you are freezing, sometimes
in
again
fact,
it's open.
Just be,
Increase
Lordship,
percentage
as per-
19.48, 30.43.
I am supposed to complete the project by 7th of the July.
Time is given to you up till 7th of July.
I have
isn't it?
already increased and my manpower is more than what is required in the contract.
No, time is given to
Yes,
you up
Lordship.
till 7th of July. Correct.
By this time I will be able to finish the work.
What is the time given to you? 7th
Yes,
of
Lordship.
July.
7th of July. Yes.
So why do you want to complete on 7th of July? Why not complete before
7th
that?
of July. 1 year from the date of signing of the
Agreement was signed
It
on
will
which
be
date?
completed. It will be completed by 7th of July.
Agreement signed on which date?
It is on 7th of July 2025.
So
1 year from
1 year will be
that
7th of
period.
July 2026.
Yes, and my project will be completed within the time period.
Your endeavor should be to complete before 7th of July.
Lordship, in fact, therefore, because in the starting period, 3-4 months, we have taken only to make the road motorable because it was not motorable condition. When the NIT was issued and when the actual contract agreement signed, there was more than a 1 year gap. So the road condition was totally deteriorated. So first I have made the road motorable. Thereafter I have taken the work of subgrading, and now the road is trafficable. And therefore, Lordship, in case if my progress can be seen, for the project 1 I am achieving 55%, for the progress for the package 66.00. Lordship, furthermore, there is one more thing, that in view of the Iran tension, there has been bad impact on the supply of the bituminous. Its rate has been doubled. So now that issue has also been resolved by the ministry. So that's why on instruction I am saying that within the time period granted to me, the project will be completed.
How is the issue resolved?
Lordship, I have annexed one circular of the ministry because the rate of bitumen was fluctuated, it became double. So in my contract, there was no provision for any price variation. Now the ministry has come into picture and they are saying that the price variation will be given for the purchase of the bituminous.
Circular dated 17th April.
Yes, Lordship.
Okay. Going back to my earlier query.
Yes, Lordship.
If you plan to complete before 7th of July.
Yes, Lordship.
Then only you will be able to complete by 7th of July.
We plan it before that.
If you plan to complete by 7th of July, then there will be some extended time.
No, it will be well within that period. Before that, we will be able to complete because, Lordship, the major 49% of the project 1 is of the bituminous work. So now the bituminous has been resolved. So therefore, I am saying that I will be able to complete it. And in fact, Lordship, I have also given the table of chart stating that what was the actual scope of the quantity and what I have done. So Lordship, in fact, Kindly see page 10, para 9.
What is this BC?
Bituminous, Lordship.
C stands for what? Concrete.
Yes, Lordship. Bituminous concrete.
Bituminous concrete.
Yes, Lordship.
See now, you know, in this part of the country, June, July would be, monsoon will start in June.
Yes, Lordship.
July will be the peak time when monsoon prevails here.
Yes, Lordship.
So that is why what we are saying is that your target should be before 7th of July. Then only you can do it within that time. If you
Our endeavor is, but I am taking a safer date so that in any case I am taking the last date, that by this date I will be able to complete, or before that I will be able to complete.
We understand. It is always safer to take the last date, but
Yes,
your endeavor should be before July, because you see July would be a bad season for you to complete all these things.
Yes, Lordship. Yes, Lordship.
Because of the monsoon.
Yes, Lordship.
Brother, 7th of July is a distant date. Okay. Maybe we fix this matter again after a month and ask them to give us the status so that we can monitor. So that they also can do that.
Lordship, my progress is also being monitored by the authority. They have authority, engineer authority. They have also filed affidavit.
Okay, so we'll do one thing. We'll take into account what you have stated in your affidavit, as well as the affidavit of the, what do you call this, engineer.
Yes, Lordship.
And we'll post the matter again after a month. And you will,
Yes, Lordship.
you will be required to intimate the court again about the progress made in the similar fashion which you have done today.
Right,
so
Lordship.
you have given us things in detail, it's very good. But do the same thing again after a month. We post it again after a month, so that we would like to know how you progress. Okay?
Yes, Lordship.
Anything to be said?
Lordship, work has been, it's in action right now, so.
Yes, let them do it. I think they are taking up all the steps required. But we'll post it again after a month and let them give us the status by then. Art Miss Emily Changte, learned. You're the amicus?
No, my lord.
Learned counsel for the petitioner.
For the petitioner.
Mr. Samuel Vanarshi.
Anil Kumar.
Samuel Vanarshi Changte, learned additional advocate general.
No, my lord, as a standing counsel.
I'm sorry, learned counsel, learned standing counsel. Standing counsel of?
NHIDCL 7
Learned
to 10.
standing counsel NHIDCL appearing for respondent numbers?
7 to 10, my lord.
7 to 10.
Yes, my lord.
Ms. Zairem Sangpui, learned CGC, representing respondent number 6. And Miss, your good name? Miss Lalrin Diki, learned counsel, appearing on behalf of Miss Van Siami, learned government advocate, representing the state respondents. Next para. In terms of the last court's order, the respondent numbers. Okay, one more line. Also had Mr.
Anil Kumar.
Anil Kumar, learned counsel for respondent number 12. Then next para. In terms of the last court's order, dated 25/3/2026, the respondent numbers 7 to
7 to 10, my lord.
10.
Yes, my lord.
as well as the respondent number 12 have filed their respective affidavit. Stop. Respondent number 7 to 10 are the authorities in the NHIDCL, while respondent number 12 is the contractor carrying out the work. Next para. Be it stated herein that as per the last court's order, the respondents concerned were required to inform the court as to whether limestone rocks are being used for repair and construction of the National Highway 306 and 06 pertaining to package number 3 to 8. Along the Konpui-Khamrang-Sairang stretch at KM 70 to KM 95 and KM 118 to 113. To stop, the respondent number 12 has specifically stated at paragraph number 4 of their additional affidavit that no limestone rocks are being utilized for the contract work, and that usage of the same is expressly prohibited under the applicable standards. To stop. In other words, the respondent number 12 has stated that the applicable standards are strictly complied with and there is no usage of limestone rocks. Stop. Similarly, the respondent numbers 7 to 10 in their affidavit have also stated that as per the undertaking / certification of work execution dated 13/4/2026 issued by the authority engineers, no limestone rocks are being used by the contractor in the project based on visual inspection and monitoring. Stop. It is also stated that samples of the materials have been sent to a third party NABL-accredited laboratory for testing and verification. Next para. The respondent number 12 in the additional affidavit has also provided a chart indicating the increased percentage of work progress between the period 23-2026 to 19-4-2026 at the rate of 19.48% in respect of Project 1 bracket KM 70-95. Stop. Similarly, in respect of Project 2 bracket KM 118-133 and 147.8-159 close bracket, the increased percentage of work progress is 30.43%. Stop. Insofar as the financial progress is concerned, the same stands at 23.45% and 33.78% for the two projects respectively. Stop. This apart, the respondent number 12 at paragraph number 8 of the additional affidavit has also stated that there is increase in deployment of manpower compared to the earlier period. What would be the earlier period, Mr. Counsel?
Lordship, in February we had filed one.
February.
There was earlier we had shown this that one.
Earlier
Yes,
figure was of which month? February.
In fact, in every month we are giving the figure, Lordship.
No, if you have page number 9 of your affidavit.
Yes, Lordship. This figure we have stated in.
Bottom of the page, previously 87 numbers and 96 numbers.
Yes, Lordship.
This is for which period?
2nd February affidavit. Just 1 minute, Lordship. January affidavit, Lordship. 21st of January 2026.
January. Please
Yes,
read the last sentence. No increase. There is increase now. There is increase. Read the sentence. There is increase. Manpower compared to the earlier period, which was in the month of January 2026. The Learned Counsel also submits that Where have you stated about that West Asia?
Lordship, because it has the impact over the bituminous supply, and in fact, not in my project, all the projects, they have been hampered on account of the shortfall of the bituminous and high rise of the bituminous price. So that is also one of the major impact which has hindered my progress.
No, where have you stated that?
Lordship, it is. Yep.
No. Learned Counsel further submits that due to the surge in bitumen prices because of the West Asian geopolitical tension, the respondent number 12 was facing some problem but the same has now been resolved in view of the circular issued by the Ministry of Road Transport and Highways on 17/4/2026. Stop. The respondent number 12 has therefore resumed full pace bituminous execution and is committed to completing all the balance works by 7/7/2026. Stop. The Learned Counsel for respondent number 12 has drawn our attention to paragraph number 9 of the additional affidavit, wherein the respondent number 12 has demonstrated the manner in which it intends to complete the remaining 65% of the work.
Now there will be less percentage, Lordship, because in the last order there was 65%. So some progress we have achieved. So now there will be less.
Learned Counsel for the respondent number 12 submits that since the respondent number 12 has made some progress of the work, the remaining balance of work would be lesser than 65% as of now. Upon perusal of the statements made in the additional affidavit filed by the respondent numbers 7 to 10 and the respondent number 12, we find that the work is in progress, but however, having regard to the fact that monsoon is will be due from the month of June, the respondent number 12 will be required to make all endeavors to complete the entire project work. Keeping in mind the incoming monsoon. Stop. As the petitioner, as the respondent number 12 has demonstrated the progress and the endeavor to complete the work by 7th of July 2026. We deem it appropriate to take up the matter again after a month from today to see the manner in which progress is being made. Stop. In order to appreciate the progress being made, the respondent number 12 will be required to file an affidavit incorporating the progress being made, pace at which the work is being carried out, and also the quality of the same. Stop. Since a statement has been made in the additional affidavit by the respondent number 7 to 10 that sample of the materials had been sent to the third party to see the quality of the materials used for the project. The respondent number 7 to 10 shall also file their additional affidavit incorporating the results of the test and also details of how they are monitoring the execution of the work. To stop, the respondent numbers 7 to 10 as well as the respondent number 12 shall file their respective affidavits on or before April, May. We list in June, what? 10th. 10th of June. On or before 5th of June 2026. List the matter again on 10th of June 2026.
Lordship, I have one more submission.
Yes.
Recently, some unidentified persons have visited my site. They have threatened my project engineer, project manager, as well the other site officer, that complete it within 2 days, 3 days. Otherwise, we will kill you. We will fire your machineries and all these things. So we are also approaching to the district administration in case if a line of observation may come from the lordship that district administration should provide us the safety in this regard. It will be highly appreciated for us, because that is also one of the, because my project manager, one project manager has gone, because such type of incidents, this demoralizes the workers who are at site.
Next para, before parting with this order, Mr. What is your name?
Anil Kumar.
Mr. Anil Kumar, Learned Counsel for Respondent number 12, has informed the court that the respondent number 12 and the persons engaged by him in the project have recently received some threat from unidentified persons, and for which reason the respondent number 12 has apprehension for the safety of his workers. If such is the situation, the respondent number 12 should approach the district administration with appropriate application or report, and in the event of respondent number 12 making such an approach, the district administration would be required to look into the matter to address the issue. All right.
Yes, highly obliged.
Yes.
My lord, the learned AG will be appearing, my lord.
Oh, okay. Mr. Deb?
My Lord,
Yes.
now the petitioner before your lordship is the Mizoram State Healthcare Society, represented by the SPIO and the Deputy Chief Executive Officer, the former SPIO and the Deputy Executive Officer, and the Chief Executive Officer. Now, the brief facts of the case, my lord, in a nutshell, is that on 1st of November 2025, the respondent number 3 submitted an RTI application seeking information relating to an agreement which was signed between the Mizoram State Healthcare Society and the Synod Hospital, Dutlang, Aizawl, along with detailed pricing, etc. So, on the basis of that, some information was provided to the applicant, to the respondent, and it was mentioned that the agreement which they are seeking information for is a confidential agreement, section 14 of the agreement. I'll take your lordship to that particular part of the agreement. And since it is a third party agreement, it cannot be disclosed without the consent of the third party. My lord will kindly come to page 8, paragraph 3.
Page 8.
Paragraph D, my lord. I'm sorry.
Page
Paragraph
30.
D.
Page number?
Page 8.
Page 8.
Paragraph D.
Yes.
That the memorandum of agreement was signed between the Mizoram State Healthcare Society and the Synod Hospital, Dutlang, Aizawl, inserting a confidentiality clause in the MOA. Clause 14 of the Memorandum of Agreement states that each party shall maintain confidentiality relating to all matters and issues dealt with by the parties in the course of the business contemplated by and relating to this agreement. Both parties shall not disclose to any third party any information relating to this agreement and documents marked confidential, medical reports, personal information relating to beneficiaries, and other unpublished information except unless mutually agreed upon by both the parties in writing, and shall use its best efforts to ensure that its officers, employees, keep secret all the information disclosed. This is the gist of the paragraph 14 of the agreement. That the Mizoram Healthcare Society sought permission from the Mizoram Synod, for which the Mizoram Synod duly replied stating that they stand with the non-disclosure of the MOA, that the impugned order, thereafter I'll come to the impugned order, my lord, the impugned order has failed to appreciate the confidentiality clause signed between the parties, that the information sought is personal and its disclosure would cause unwarranted invasion of privacy with no larger public interest involved. Thereafter, my lord, if I can take your lordships to page 16. The impugned order starts from page 13. If your lordship can kindly come to page 16. The decision of the commission. The decision of the State Information Commissioner. Lordship, page 16. Last paragraph, my lord.
Yes.
Page 16, last paragraph. Decision. In view of the circumstances, the Commission hereby directs that Dr. K. Langlinglova, SPIO and Chief Finance Officer, Mizoram State Healthcare Society shall provide the information sought to the complainant free of cost not later than 17th of April 2026. Compliance report with all the documents provided should also be sent to the Commission for information. The complaint is disposed of accordingly. Copy of the decision to be given free of cost to all the parties. And my lord, after this particular impugned order which has been passed on 9th of April, Lordship will kindly come to page 28.
This is an interim order over.
No.
This is a
This
final
is an
order.
order.
This is a
It has
final
been
order.
disposed of. The application is disposed of. The direction is that the information has to be provided not later than 17th of April. So, my lord, 17th of April, the petitioner was compelled, because this honorable court was closed, my lord, for vacation during that particular time, and the petitioner was compelled to send a request for reconsideration of the CIC decision. My lord will kindly come to page 31. But prior to that, I would take your lordship to page 30, wherein, prior to that, my lord, page 30,
30, yes.
wherein the Mizoram Presbyterian Church, Synod Office, Aizol, has specifically written a letter to Dr. Ralte, IAS, Chief Executive Officer, Mizoram State Healthcare Society, Aizol. Subject, issuance of MOA for answering RTI application. Dear Madam, as highlighted under clause 14, confidentiality of the agreement of the MOA of MUHCS, unless there is a written representation of consent from both the first party and second party, no copy of the agreement or any part thereof of the agreement can be issued or disclosed to any third party. I, therefore, am of the opinion that this RTI application is unanswerable. Unanswerable. So thereafter, my lord, since the order, impugned order which was passed by the CIC, dated 9th of April, specifically mentions that the reply has to be given by 17th of April. And the petitioner had no other option because this honorable court was closed for vacation. So a letter of request was sent for reconsideration of the decision.
Where is that?
It is at page 31, my lord.
31, yes.
And this is where, my lord, there is a short question of law, which my lord will kindly look into the matter. And this is very simple matter. The State Chief Information Commissioner, Mizoram Information Commission, Aizol, Mizoram. Request for reconsideration of CIC decision. Decision number so and so. Dear sir, I have the honor to refer to the order passed by the Chief Information Commission, Mizoram, in the matter of case number C 173/2006 MIC dated 10th of April 2026, wherein this office has been directed to furnish reply, compliance within a stipulated period. In this regard, it is submitted. Now, my lord, comes the question of law. In this regard, it is submitted that under section 19(4) of the Right to Information Act 2005, the interest and objections of the concerned third party are required to be duly considered. Lordship, thereafter, the section 19(4) has been quoted below. If the decision of the Central Public Information Officer or the State Information Officer, as the case may be, against which an appeal is preferred, relates to information of a third party, the Central Information Commission or State Information Commission, as the case may be, shall give a reasonable opportunity of being heard to that third party. So here, my lord, the third party has not been issued, neither been issued any notice, nor has been heard. So it is a direct violation of section 19(4), which has been committed by the Information Commission, Mizoram Information Commission. So on this ground itself, the order needs to be set aside. That is my humble submission. First submission, my lord. Secondly, my lord, we'll come to the remaining part of the letter which has been submitted for the consideration, same page. In the present case, the third party was not given any notice of reasonable opportunity of being heard. Further, under section 19(9) of the Act, Lordship, this 19(9) has also been quoted. The Central Information Commission or State Information Commission, as the case may be, shall give notice of its decision, including any right of appeal, to the complainant and the public authority. Now, my lord, here, however, as per the order, no right of appeal has been given to the public authority or the third party. Has been given the opportunity of being heard as stipulated in the Act. So there is a second violation of the Act. Neither the order mentions about the right of appeal, nor notice has been issued to the third party, that is the Mizoram Synod. Neither a reasonable opportunity of being heard has been given third party under the provisions of section 19(4) of the Act. So this is my humble submission, my lord, very short submission, that there has been a violation of section 19(4) and 19(9) of the Act. And my humble submission that this particular impugned order dated 9th of April 2026 may be set aside. This is my humble submission. It's a clear violation of the Act, my lord. And this needs intervention from your lordship.
All right, we issue notice today. Heard Mr. Bishwajit Deb, Learned Advocate General, Mizoram, assisted by Mr. Samuel Balaji Chante, Learned Additional AG, for the petitioners, who submits that the petitioners are the Mizoram State Healthcare Society, represented by the SPIO and Deputy Chief Executive Officer.
And the Chief Executive Officer also, my lord.
And also the Chief Executive Officer. And they are aggrieved with the decision rendered by the State Chief Information Commissioner dated 9/4/2026, by which the petitioners have been directed to provide information sought for by the respondent number 3 / complainant, free of cost, not later than 17/4/2026. The Learned Advocate General submits that an agreement was entered into between the Mizoram State Healthcare Society on one part and the Synod Hospital Durtla Aizawl on the other. Stop. As per the said agreement, there is a specific clause which provides that.
Clause number 14.
Paragraph 14.
Clause number 14 of the agreement.
Page 8, Malad.
Clause 14. Clause 14 of the memorandum of agreement.
Page 8.
Lordship will seek page
provides
6.
that each party shall maintain confidentiality relating to all matters and issue dealt with by the parties in the course of business contemplated. Relating to the agreement. Stop that both parties shall not disclose to any third party any information relating to the agreement and the documents marked confidential, medical reports, personal information relating to beneficiary and other unpublished information, except unless mutually agreed upon by both the parties in writing. Stop. Accordingly, the information sought by the respondent number 3 was responded to by the SPIO informing
Page 14A.
about the specific clause which prevented divulging of information unless the parties specifically agree to give the same in writing. To stop the complainant, therefore, took up the matter before the State Chief Information Commissioner, who thereupon passed the impugn order dated 9/4/2026. To stop, the petitioner has agreed with the order, had also approached the said authority with a request for reconsidering the decision on 17/4/2026, but the same but the said authority has failed to consider the same, and the petitioners, having no alternative, are before this court through the instant writ petition. Next para, the learned Advocate General has submitted that in passing the impugn order, the respondent authority concerned has failed to take into consideration the provisions of Section 19(4) of the Right to Information Act 2005, which provides that reasonable opportunity of being heard is to be provided to the third party. Stop. In the present case, no such opportunity was granted, and therefore, in addition to section 19 bracket 4 of the Act, comma, section 19 bracket 9 of the same Act, has also been violated. So, stop. Under this circumstance, the Learned Advocate General submits that the impugned order dated
April
9/4/2026 cannot be sustained, and the same should be set aside. Next para, in view of above, issue notice of motion returnable by 3 weeks. Petitioners to take steps for service of notice upon the respondents by speed post within 3 days.
Lordship, stay of impugned order in the meantime.
Next para, having regard to the projection made by the petitioners, in the interim it is provided herein that the impugned order dated 9/4/2026 shall remain stayed till the next returnable date. List the matter again on 12th of May.
Lordship.
In the beginning.
12th, my lord, I have got a problem, my lord. 12th I have to attend Supreme Court. If my lord can kindly fix it after that.
14th?
The week thereafter.
Week thereafter, okay, then 18 May.
Deeply obliged, my lord.
18 May. In the beginning, at the outset, you write like this. This matter has been taken up as an unlisted motion on a mention made by Mr. Samuel Vamsheta Changte, Learned Additional AG. That line only.
And deeply obliged, my lord.
Right.
Hearing items 6 and 7.
Mr. Ramzawa, what is this matter?
Lordship, this matter regarding non-payment of compensation as awarded by the competent authority in respect of the lands lying in the border. This is in connection with the Indo-Bangla border fencing. Lordship, award was made and it was approved by the government, by the competent authority. The award of 2009 was approved in 2016. Lordship, perusal of the draft award at page 29 will indicate that the lands at different stations such as Kozoi Suri,
This matter was taken up, handled by Mr. Lianshima earlier.
I don't know.
Because the first order.
Oh yeah.
20.
Lordship, I think there's a mistake in the order.
There's a mistake in the order.
Mistake in the order.
Okay. And who's for the other side?
My Lord,
Mr. Priyank.
yes, my Lord, I am appearing for NPCC. My Lord, in WPC number 17 of 2024, where Learned Senior Ramjawa is appeared, there I am 527 respondent. And in the other matter, I am respondent number 123.
NPCC.
And NP, National Projects Construction Corporation Limited.
NPCC.
My Lord, basically this, before my learned senior argues his, this proceeding has lapsed under 11A, section 11A.
11A
of Land Acquisition Act, my Lord.
1894.
So, yes, my Lord. So, and that has been admitted by petitioner in Senior Ramjawa sir's case and that in reply affidavit. So, and Supreme Court has stated that if it lapses, there is a judgment which the local council, Loma or Alte, will be furnishing it to you, my Lord. And along with a note also. Note is not written argument, but I already got thrice disconnected, so that is why I have sent that note.
What has the Supreme Court said?
My Lord, Supreme Court says that if it lapses, then it has to be restarted from afresh from section 4 notice. And this will come under, because in the meantime, the act has changed to 2013 act, so it will start from section 11. So it is a very short matter.
So you are saying that if it lapses, then we have to go, it has to be done afresh.
Yes, my Lord. And
at this point of time, it will be under the 2013 Act.
Yes, my Lord. And there is another issue that NPCC is continuously telling it to the state government that this is the land acquired is for link roads, and we have not acquired that link roads. So if it goes for a fresh acquisition, at least everything will get cleared.
So you are agreeable for fresh acquisition?
My Lord, this is what Supreme Court has said. And definitely Supreme Court has the plenary power under Article 142, but here we cannot do that, my Lord, to accept this acquisition.
Okay. So
that appears to be the case of the respondents. Your Lordship, if I'm allowed to place the facts, we're not saying that
why are these two cases clubbed together? They are same.
It has come under the same award.
Same award.
Same award by persons who are affected under different petitions.
How many awards are there?
Only one award. That is draft award number 5 of 2009.
So that draft award covers both the writ petitions?
Yes.
Yes, my Lord.
Okay.
My Lord, in this writ petition,
if the award has lapsed, and if it's required to be initiated afresh, are you not agreeable to that?
We do not say that it has lapsed. Lordship, there's a provision under section 24 of the new Act, 2013 Act. The question of fresh proceeding will not arise, but fresh assessment will have to be made.
Fresh assessment?
Fresh assessment under 2013 Act.
Okay.
If I take a Lordship to
See,
section
before
24.
you start, I will have to tell you that this court will have to rise at 4 o'clock. So we have precisely about 35 minutes.
We can continue tomorrow.
This is a difficulty.
If it can be continued till tomorrow.
My Lord, if 27th, if there is no difficulty of the court, 27th Monday.
That would be ideal, I think, Mr. Ramzawa. Because tomorrow again, some other things are there, second half. Then Friday is there again. Today's Wednesday, isn't it? Wednesday.
Yes.
It'll be better if you have it on Monday. You will be there through VC only? Or you
I'll
coming?
be there. No, my lord, actually tomorrow I have some difficulty regarding doctor's appointment of my mother.
No. On 27th. Can you
I
come?
will be on VC. I will be on VC, my lord.
You'll be on VC. You cannot come
Yes,
physically. Okay.
No, yes, my lord.
Okay. Mr. Ramzawa?
Since it will not be possible on the part of a lordship to complete the matter.
That's the problem, you see. I would not like to keep things pending like that. We'll fix it on 27th.
Yes, my lord.
All right, Monday.
Yes, sir.
As agreed to by the parties, let the matter be listed for hearing as a fixed item on 27th of April 2026.
Lordship, so far as the other matter, WPC 73/2019, item number 5 is concerned. One affidavit has been submitted, additional affidavit has been submitted by the respondent number 5. And we may have to file a reply to the affidavit.
Item 5?
Item 5, yes, Your Lordship.
5, we have passed an order this morning.
Yes, my lord. It is because of my prayer for 4 weeks' time, thinking that Mr. Ramjawa sir would be filing an reply in affidavit, and that is already reflected in last order that he would be reserving his right for filing an affidavit.
All right.
You may file.
We'll do that.
That is why I have taken 4 weeks' time. My lord.
Okay. Okay.
Much obliged.